Hello, my name is Ed Cape. I'm Professor of Criminal Law and Practice at Bristol Law School in the University of the West of England, Bristol in the United Kingdom. And today I want to talk to you about the role of the lawyer at the investigative stage of the criminal process in England and Wales. Now, to provide a bit of context, I want to briefly review the EU Directive on the Right of Access to a Lawyer. So under the directive, a right of access to a lawyer applies throughout criminal proceedings to allow suspects and accused persons to exercise their rights of defence practically and effectively. And it provides for this right at a number of stages at the investigative stage. Firstly, before they are questioned by police or other law enforcement or judicial authority. Secondly, when investigative acts which a suspect is required or permitted to attend are carried out. And thirdly, without undue delay after deprivation of liberty. And it goes on to provide that suspects and accused people have a right to meet in private and to communicate with their lawyer, including prior to any police interrogation, and also a right for the lawyer to be present and to participate effectively, a very important phrase which I will be talking about later, when a suspect or accused person is questioned. Now, as far as England and Wales is concerned, a right of access to a lawyer at the investigative stage has existed since 1986, when the Police and Criminal Evidence Act of 1984 came into force. And this provides that a person who's been arrested and who is held in custody in a police station or other premises shall be entitled, if he so requests, to consult a solicitor privately at any time. In addition, suspects who voluntarily attend the police station in connection with a criminal investigation are also entitled to consult a solicitor. The statutory provisions are bolstered by a statutory code, which is called Code of Practice C, which regulates the process in much greater detail. Now, Code C provides for a number of things. For example, it provides for the letter of rights to be given to a suspect when they are detained at a police station. It governs the way in which interrogations are to be carried out. It requires the police to disclose certain information in advance of an interrogation. And it makes a number of other provisions, detailed provisions regarding the investigative process and in relation to the right of access to a lawyer. Now, I said that the right of access to a lawyer was introduced in 1986, and research showed that there were quite a lot of problems in the first decade in particular after the right was introduced. And it's quite interesting that the problems that were experienced in England and Wales during the latter part of the 1980s and the early part of the 1990s are now being encountered in many jurisdictions across Europe where the right of access to a lawyer has recently been introduced or is about to be introduced. And I'll just tell you about some of them. Now, first of all, there was quite a low level of take-up by suspects. Only about 25% of suspects asked for a lawyer at the initial stages. This has now increased quite significantly, so that now about half of all suspects ask for the advice of a solicitor. One of the reasons why there was low take-up by suspects was the strategies that were adopted by the police to encourage suspects to waive their right to a lawyer. And they would do this in a number of different ways. One way was to downplay the importance or the seriousness of the offence for which the suspect was being questioned, and in effect to indicate to suspects that therefore they did not need a lawyer. Another way, which was quite clever from the police perspective, was to encourage suspects to believe that if they asked for a lawyer, then their detention would be prolonged. And that was quite clever because the police were aware that most suspects, what they most want is to get out of custody as quickly as possible, never mind the consequences. And therefore, if the suspect believed that asking for a lawyer would mean that they would spend longer in the police station, then they would be less inclined to ask for legal assistance. A third finding of the research was that lawyers themselves did not necessarily provide services which they should be providing. And in particular, some lawyers were particularly prone to providing advice only on the telephone in circumstances where they should have attended the police station and their clients in person. And one reason for that is that many law firms were not set up in order to enable them to be able to send a lawyer to the police station at short notice, and particularly out of office hours. Now, as far as the role of the lawyer in police interrogations was concerned, the police adopted a number of strategies to neutralise lawyers during interrogations. And again, they did this in a number of ways. One way was to try to force the lawyer to sit behind their client, away from their client, in the corner of the interrogation room. So that in that way, the lawyer did not have eye contact with the suspect. The suspect, in effect, could be encouraged to believe that the lawyer was not present and to interfere with communication between the suspect and their lawyer. Another strategy adopted by the police was to encourage the suspect to disregard the advice given by their lawyer, telling them they didn't need to follow that advice, particularly if the client was not answering police questions. And the police would often seek to undermine the right to silence in other ways. And if the suspect said that they did not want to answer questions, then the police would often repeatedly try to encourage them to change their minds. And then finally, the research discovered that a minority of, not just a minority, actually a majority of lawyers would normally play quite a passive role during the course of the interrogation. So that they would not intervene and in effect would simply remain silent during the whole course of the interrogation. And that was exacerbated by the fact that for many lawyers this was a new aspect of their job and they were not really clear about what it is that they should do and not clear about what they were permitted to do during the course of the police interrogation. So what I want to tell you about are a number of key developments which over the next decade or so improved both the take-up of legal advice and the quality of the service that lawyers were providing to clients at the police station. Now, the first that I want to mention is a key judgment of the Court of Appeal in a case which came to be known as the Cardiff 3 case. Now, the Cardiff 3 case involved 5 people who were arrested for the murder of a woman who in fact was the partner of one of the suspects. One of the suspects was a man called Miller who had borderline learning difficulties. And in his case, the police arrested him for suspected murder, and they interviewed him over a period of 5 days for a total of 19 hours. Now, he had a lawyer present in all of those interrogations, but the lawyer, for the most part, sat silent during the course of the interrogations. And that was despite the fact that the police, as we shall see in a moment, acted in an oppressive way. They repeatedly told Miller that he had murdered his partner. And whenever he denied it, they said to him that was not true. They often shouted at him and at times Miller was reduced to a very poor state and crying, etc. And only on one occasion did the lawyer try to intervene to stop that. And when he did try to intervene, the police simply said, "This is our interview, we'll conduct it how we want to." And essentially the solicitor did not pursue it and remained silent for the rest of the interviews that were carried out. And in the end, Miller confessed to the murder, and subsequently he and two of the co-suspects, Paris and Abdullahi, were convicted of her murder. Now, when they appealed to the Court of Appeal listened to the audio recordings of the interviews. And what they said was that short of physical violence, they could not imagine more oppressive interviews. And ultimately, they said that the interviews should not have been given in evidence because of that oppression. So the court was very critical of the police in carrying out the interviews in an oppressive way, but it was also very critical of the lawyer. And as you can see, what they said is that the solicitor who sat in on the interviews seemed to have done that and little else. We can only assume that in the present case, the police officers took the view that unless and until the solicitor intervened, they could not be criticised for going too far. So the court was making the important point that a lawyer who is passive can actually make things worse for their client, because not only would it make it less likely that evidence of the interviews would be excluded, but also it would encourage the police to carry on in the way that they were doing so, even though that was oppressive and contrary to the law. So that was the first of the key developments. The second was the introduction of an accreditation scheme. Now, England and Wales was quite peculiar in the sense that solicitors were permitted to send unqualified staff to the police station to provide advice to their clients. And research demonstrated that those representatives, as they came to be called, were often not simply unqualified in a technical sense, but were unqualified in that they had little or no knowledge of the law and did not have the skills which were necessary to do their job properly. Now, as a result of those research findings, the Law Society and the legal aid authorities introduced an accreditation scheme under which representatives would have to demonstrate their competence, both in terms of their knowledge and their skills. And research showed that that accreditation scheme led to an improvement in quality, and as a result, the accreditation scheme was extended to include all solicitors providing advice at police stations under the legal aid scheme. Now, one of the things that the accreditation scheme required was for the Law Society to set out in detail what it expected lawyers to do when acting for clients at the police station. And they published standards of performance, which I'm going to refer to later on. Partly as a result of the accreditation scheme, the Law Society, which is the professional body for solicitors, which is one branch of the legal profession, introduced training obligations, sometimes known as continuing professional development requirements. And it was recognised that to be competent, it did not only require a lawyer to have the relevant knowledge, but also to have the relevant skills. And so the training programs that were developed during the mid-1990s emphasized the relevant skills such as the skills of interviewing clients, taking instructions from clients, recording interrogations, and negotiating with the police. And then the fourth development was the adoption by the Law Society of an active defence approach. Now, in 1993, I had published a book, Defending Suspects at Police Stations, and I had deliberately chosen that title to convey the idea that the role of the lawyer is not simply to advise clients at police stations, but to positively defend them. And that notion was accepted by the Law Society, and it articulated this active defence approach, which meant that, which involved the idea that lawyers should not simply be advising clients, but they should be acting positively in a way which amounted to defending their client at this initial stages of the criminal process. And then there was a fifth development, which was initiated by the Law Society, and this was a positive statement of the lawyer's role, which was incorporated into the Statutory Code of Practice C. Now let me just read through that. So it says, the solicitor's only role in the police station is to protect and advance the legal rights of their client. On occasions, this may require the solicitor to give advice which has the effect of the client avoiding giving evidence which strengthens the prosecution case. And then, importantly, it went on to set out the circumstances in which it was legitimate for the lawyer to intervene during police interrogations. So the solicitor may intervene in the police interrogation in order to seek clarification, to challenge an improper question to their client, or the manner, the way in which the question is put or the questioning is conducted, to advise their client not to reply to a particular question, but also that they may intervene if they wish to give their client further legal advice. In effect, what that meant was that lawyers were entitled to stop the police interview so that they could give their client further advice in confidence. Now, that's not something that the police, of course, liked, but the fact that it was incorporated into the statutory code meant that it was quite clear that the lawyer was entitled to do this. And the advantage of this statement in the Code of Practice was that not only lawyers and their clients could be clear about the parameters of the lawyer's role, both generally and in the police interrogation, but the police would also be clear that, for example, if a solicitor sought to stop an interview in order to advise their client, that they were perfectly entitled to do so. So what does this mean, and what did it mean in practice? Well, the best way, I think, to examine the lawyer's role in practice in England and Wales is to look at the standards of performance that were developed by the Law Society. Now, these standards of performance are, in effect, a mechanism to establish in detail what the lawyer is expected to do at the investigative stage of the criminal process, and to set that out in detail, and also to make it clear what the level of performance should be. So I'll just go through the major headings, firstly, of the standards of performance. First, we see is the duty to respond to the request to attend the police station. I'll come back to that in a moment. Secondly, the obligation to consult with appropriate officers at the police station, which might include the custody officer who has responsibility for detaining suspects, but also the investigation officers, what we call the officers in the case. Thirdly, and perhaps obviously, but nevertheless it needed to be there in the standards, was to consult with the client. And then fourthly, the fourth standard involves the monitoring of and intervention during police interrogations, and I'll come back to that later on. So far that sort of follows the chronology of advising clients at police stations, and then we have two specific standards, one relating to acting for vulnerable clients, that is, suspects who may be vulnerable through age or mental health, and then also the obligations of the lawyer during any identification procedures, such as identification parades or video identifications. And then finally, and very important, is this standard regarding representing the client after the interrogation or identification procedure, because it was recognized that the role of the lawyer should not stop when an interrogation finishes, but there is still work to be done after any interrogation. For example, in order to advise the client about how the interrogation had gone, whether the suspect should be saying anything more to the police and whether they should be asking for another interview, what is likely to happen in the immediate future. Is there likely to be another interview, or is the suspect likely to be charged, or is there the opportunity to persuade the police to deal with it by way of some kind of out-of-court disposal? So those are the standards of performance. And each one of those standards is then broken down into a number of constituent, more detailed elements. Now, I don't have time to go through all of those, but what I will do is I'll take two of those standards and what I'll do is tell you about, well, how are they broken down? What are the particular things that are then required? So we'll look at the standard first of all, which is the one concerning the initial consultation with the client. So the first element of that is that the lawyer should introduce themselves to the client and make an assessment of the client. Now, this is important, this introduction and assessment, for a number of reasons, but it must be remembered that suspects who've been arrested and detained at police stations may be in a variety of emotional states. That may result from their own circumstances, their psychological circumstances, the fact that they have just been arrested and removed from everything that is familiar, but also as a result of the way in which that arrest has been carried out, and also as a result of the seriousness of the offence for which they have been arrested. So important to remember that clients may be in those variety of emotional states, and also some clients may never have been arrested before. Others might be quite familiar with the process, but for others it's completely new. And so in this first element of introduction to an assessment of the client, this involves firstly the idea of the lawyer informing the client about who they are, and what their professional status is. And that will be particularly important for a client who's never met that lawyer before, or perhaps for a client who's never been in this position before. Secondly, the lawyer should take steps to assess the vulnerability of their client. Are they a child? Do they suffer from any mental difficulties? Have they suffered from any physical injuries? Are they extremely tired for any particular reason? Are they suffering from the effects of alcohol or drugs? And as part of that assessment of their client's vulnerability, they should also be making an assessment of their fitness for interview. Now, of course, lawyers are not medical experts, but there are a number of very relatively simple ways in which the lawyer can make an initial assessment of fitness for interview, and then, if necessary, take appropriate action if they feel that they are not fit or may not be fit, in particular calling in a medical practitioner or asking the police to call in a medical practitioner. And then it also requires the lawyer to deal with any complaints the suspect might have. Because the suspect may have a number of things which are concerning them, which may well, if they're not dealt with, have the effect of reducing their performance during any police interrogation. Well, first of all, that this is not a complaint as such, but they may be worried if they have children and they're not sure who's going to pick the children up from school, or they're worried about what their partner is going to think if they don't know where they are. But it may also be the case that a suspect may have specific complaints about the treatment that they've received from the police, whether they've been ill-treated by the police in any way, whether physical force was used on them during the course of the arrest or the detention. And so it stresses the importance of discovering these kinds of problems from clients so that appropriate action can be taken. So it's not simply a question of finding out this information, but it also requires the lawyer to do what is necessary if they discover that there are particular problems. It might be simply to make arrangements for their children to be picked up from school, or it might be to at least advise them about making a complaint about police conduct. This particular standard then goes on. The next stage is then giving information and advice to the client. Firstly, to tell the client what offence they are suspected of, because that may not be clear to their client. The police may not have informed them of the reason for arrest, or they may have only simply given them a very brief justification for the arrest. But the client also needs to know, well, what are the constituent elements of that offence? Because, of course, whether someone has committed an offence is not simply a question of whether they've done a physical act or made a particular omission, but also involves the mental element, the mens rea of the offence. And also the lawyer should be telling the client, well, what does the lawyer know so far about the evidence that the police have? Now that, of course, is going to depend on the particular case. It will also depend on the particular jurisdiction, because in some countries the police are much more willing to give initial information to the lawyer than they are in other jurisdictions. And then, having given the client that information, it's for the lawyer then to take, in the English and Welsh context, what we call instructions, to gather information from the client about what they know, if anything, about the suspected offence. And normally that should be detailed information, bearing in mind the kinds of questions that the lawyer expects the police to ask their client during the police interrogation. And then, using all of that information, so the information that the lawyer has obtained from the police, the information that the lawyer has obtained from the client, then to give reasoned advice, advice in which they are not simply telling the client what they think they should do, but why they think they should do it. So giving reasoned advice about the strategy to be adopted in the interrogation. Should they answer questions? Should they not answer questions in particular? But also to inform the client about the lawyer's role during the interrogation. Is the lawyer able to intervene? What the client should do if they want further legal advice, those kinds of things. So that the client goes into the interrogation knowing how they can rely on their lawyer during the course of the interrogation. So that's the one of the standards of performance. Let's just take a look at another, which concerns the police interrogation. And it's the performance standard is headed Monitoring and Intervention during the interrogation. So the first job of the lawyer is to ensure that the interrogation is conducted properly. Now, of course, that is going to depend in part upon national regulations as to what powers the police have and what the police may do during the course of an interrogation. But in the English and Welsh context, certainly, it involves firstly the lawyer taking any appropriate action if the interview room is not satisfactorily arranged. You will remember that I said that particularly in the decade after the right of access to a lawyer was introduced, that the police would sometimes try to sideline the lawyer by getting them to sit in the corner. And so if that's the case, then the lawyer needs to take action in order to be able to sit next to their client, and so that they can immediately advise their client, and the client is fully aware that the lawyer is present. And if necessary, if the police are not willing to take action as a result, it may mean that the lawyer needs to go to one of their superiors to tell them about the problem and try to insist that the interview room is satisfactorily arranged. Secondly, and again will in part depend upon national laws and regulations, that the lawyer is to challenge improper behaviour or improper questions or questioning, so that the lawyer should not simply sit back and say nothing if they believe that the police are acting inappropriately or even unlawfully or acting oppressively. And again, that might mean action during the course of the interrogation which can solve the issue there and then, or it might mean trying to stop the interview in order to take the matter up with a superior officer. Thirdly, to deal appropriately with any attempts to undermine the client's right to silence. Now, in research that's been conducted in many European jurisdictions, one of the things that is frequently encountered is that although in all countries there is, at least in theory, a right to silence, the police will frequently try to undermine that. It may simply be by repeatedly asking questions, even though the suspect is refusing to answer and has told the police that they're not going to answer questions. But in some cases, the police will increase pressure on the suspect in a variety of different ways in order to try to persuade them to speak. And if that's the case in an interrogation in which the lawyer is present, they need to be alive to those strategies which are adopted by the police to undermine the right to silence, and again, to take appropriate action. That might simply be involve the lawyer in insisting that their client has a right to silence and that they are exercising that right. It might, in an extreme case, mean trying to stop the interview and seeking the involvement of a superior officer. And then fourthly, you can see there the role of the lawyer is to ensure that the interrogation is accurately recorded. Now, in England and Wales, that's not particularly problematic because almost all police interrogations are audio recorded or audio visually recorded. But that's quite exceptional when we look across Europe, and in many European jurisdictions, the method of recording interrogations is very unsatisfactory. It may be in some jurisdictions that the interrogator is expected to try to record the interview in writing as they go along, or on computer as they go along. And very often what we have found in research is that the police do not record the questions that they put, but only record the answers. And it makes it appear as if this is just a narrative of what the suspect has said without being prompted by particular questions. And in other jurisdictions, the method of recording is for the police officer simply to type up a summary of the interview at the end. Now, in England and Wales, before audio recording was introduced, the police did record interviews in writing, and they were normally very unsatisfactory. They were normally incomplete. They were normally, in effect, biased in favour of the police perspective. But it's very often easy at the end of an interview, particularly if it's been a difficult interview or a lengthy interview, for the lawyer not to read in detail the record of the interview and simply to sign it off as being a correct and accurate account of the interview. And it's very important that in those systems, in those jurisdictions where interviews are recorded in writing or only by means of a summary, that the lawyer takes the full time that is necessary to ensure that that record of the interview or that summary of the interview is accurate. So the standards of performance then go on. This particular heading, monitoring and intervention during the interrogation, goes on, as you can see. So the next part of the role of the lawyer in the interrogation is to advise the client during the interrogation. Now, whether this can be done, as I've said, depends upon national regulations and national laws. But as we saw for England and Wales, the statutory code of practice recognises the circumstances in which the lawyer is entitled to intervene. And so in our jurisdiction, the standards of performance require the lawyer, where appropriate, to advise the client without stopping the interrogation. That might be possible if it's just a simple point upon which they can give advice. But if necessary, it requires the lawyer to stop the interrogation so that they can give the client further advice confidentially in the absence of police officers. And then thirdly, the job of the lawyer is to ensure that the client, first of all, understands the questions put to them. It may be the police are using jargon. It may be the police are using a level of language which the suspect is not equipped to understand. It may be that the suspect does not have as their first language the language which is being used by the police. So the first part of that element is to ensure that the client understands the questions that are put to them. But secondly, it requires the lawyer to ensure that the client says what they intend to say. Now, if the lawyer has carried out their consultation with the client prior to the interview, then they should have a very good idea of not only what the lawyer wants to say, but what it is advisable for them to say. It may be, for example, that if they are admitting an offence, that they ought to be providing information which mitigates their involvement in the offence. And so the lawyer needs to be alive to whether the client has got that across during the course of the interrogation. So we come to the end, and I want to emphasise the critical importance of the lawyer's function. Now, I think it's important first to say that the job of the lawyer at the police station is not an easy one. In many ways, it's harder than the job of a lawyer at court because, as I've already said, the police are sometimes hostile to the involvement of lawyers. They would much prefer to interview suspects in the absence of a lawyer. Some police officers do not believe that the lawyer's role is a legitimate one. And the lawyer is on police territory. They are there in the police station, and they are subject to the police agenda, the imperatives which govern and control the way in which the police act. And so, in a sense, the lawyer is in quite an isolated position at the police station, and particularly during the course of police interrogations. But also, of course, their client, as I've said before, may be not easy to deal with. They may be sullen, they may be angry, they may be distressed, they may be very wary of the lawyer. So for all those kinds of reasons, the role of the lawyer at the police station is a very difficult one. But as we know, the role of the lawyer at the police station is a very important one, and this was demonstrated, I think, very well by the European Court of Human Rights in the Saldus versus Turkey case. And let me just read a little bit from the judgment. The court underlines the importance of the investigation stage for the preparation of the criminal proceedings, as the evidence obtained during this stage determines the framework in which the offence charged will be considered at the trial. And of course, just to stop there, it determines not just a framework in which the offence charge will be considered at trial, it may determine whether there is a trial at all. It may determine that the police do not have sufficient evidence for proceedings to continue. Or it may be that the outcome of the police station stage is some kind of out-of-court disposal. But it goes on. At the same time, an accused often finds himself in a particularly vulnerable position at that stage of the proceedings, the effect of which is amplified by the fact that legislation on criminal procedure tends to become increasingly complex, notably with respect to the rules governing the gathering and use of evidence. In most cases, this particular vulnerability can only be properly compensated by the assistance of a lawyer whose task it is, amongst other things, to help to ensure respect for the right of an accused not to incriminate himself. And I think in finishing this presentation, it's important to say that it can only be compensated not simply by the assistance of a lawyer, but by the active, proactive assistance of a lawyer. And it's important to remember that if the lawyer does not act in that way, they're not only doing their clients a disservice, but they are also undermining their right to fair trial. Thank you.